The greatest value of human life is best represented in the recognition of fundamental rights, and in fully enabling people to enjoy and exercise these rights to the extent that preserves their humanity and respects their civility. Life would be meaningless if individuals were not able to practice their natural rights or to adopt the political opinions they believed in. Moreover, life would be unendurable if individuals were unable to enjoy security in their communities. The rights of individuals would be without value if no legal system were able to play an active role in their protection. Human rights belong to everyone, everywhere, regardless of nationality, sexuality, gender, race, religion or age. The foundation of modern human rights is the Universal Declaration of Human Rights, UDHR. The 30 articles of the Declaration were adopted in 1948 by the United Nations General Assembly, and over time these have been integrated into national laws and international treaties. It is constitutional mandate of Judiciary to protect human rights of the citizens. Supreme Court and High Courts are empowered to take action to enforce these rights. Machinery for redress is provided under Articles 32 and 226 of the Constitution. In the case of laborers working on Salal project v. State of Jammu and Kashmir, Supreme Court held that child below the age of 14 years cannot be employed and allowed to work in construction process. Children are not only prone to sexual abuse but they are also sometimes kept as bonded laborers. Concern of the Supreme Court about the protection of rights of children does not end here. It reiterated the importance of compulsory primary education vis-à-vis eradication of child labor in the case of Bandhua Mukti Morcha v. Union of India. Section 3 of the Protection of the Human Rights Act, PHRA, 1993 put an obligation of the establishment of NHRC in compliance with which central government has constituted NHRC in 1993. NHRC play a crucial part in the protection of HR and keeping the faith of the common man in the criminal justice system. NHRC and SC can complementarily protect and promote HR. A national commission can give recommendations to various authorities. It has provided recommendations in matters like health, education, police encounters, custodial deaths, etc. 21 Constitution of State Human Rights Commissions. 1. A state government may constitute a body to be known as the name of the State Human Rights Commission to exercise the powers conferred upon and to perform the functions assigned to a State Commission. Section 21 of the PHRA, 1993 empowers the state government to establish SHRC. The Act also provides the power and function of the Commission. It has to similar function as NHRC, but it can deal with the matters enlisted in the List 2 and 3 of the 7th Schedule of Indian Constitution. The deterrent point is that only 19 states have constituted the SHRC. Section 30 of the PHRA directs all the state government on an agreement of opinion with the CJI of the High Court of respective state to recognize the Court of Session as a human right court, for the speedy remedy. Section 31 provides that state shall appoint a prosecutor or an advocate with not less than 7 years' experience of practice for the purpose of dealing with the cases of this court. It was ascertained that no attempt is made by the state to consult with CJI of High Court of the respective states for scrutinizing the viability of the Session Court for specifying as NHRC.